Perfect. Okay. We will go ahead and call this meeting to order. I will ask that you join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. So, Director Moody, I'm trying to pull it up. I'm having difficulties. The process in front of me.
Sure, I can help you with that.
That'd be great.
So the first order of operations really is, at this point, this is a continued hearing. What I would do is the board can entertain a brief staff report, an update of the record, and then just because there might be new people online that weren't participating in the last hearing, I do have an opening statement that I can read that explains the rules of the hearing. And then following that, the applicant would have an opportunity to present their public comments or their comments to the application and to the comments that have been submitted. And then individuals would have an opportunity that would include the appellant and anybody that wanted to participate orally in the hearing. And then following all of those, then the applicant would have an opportunity to provide a rebuttal statement.
Okay.
So I can, with your permission, I can give a quick staff report.
I think we would all appreciate that.
Okay. So give me just 1 second here.
Well, before we get started on that real quick, Zach, again, I have to recuse myself from this as it can be seen as a direct conflict of interest for myself.
It's a continuation if you're already.
Yep. I just want to make sure it's out there and everybody understands again.
Sure. I did provide a staff report for the board to consider. I believe I provided it the first time that we had this scheduled, and so the staff report really didn't change. There is some new public comment which really says a lot of the same, provides a lot of the same information from before. So I didn't see a need to really go in and update a new staff report with a new public comment. And I figure that the folks that are here to speak today will give you a summary of their new comments if they're not included in the staff report. What I did provide for you started on page 419 of the record. And it was really just an abbreviated staff report that provided a summary of the public comments that were received at that point. And that was really through October 20th of 2025, with the last comments being received by Craig Law on October 20th of 2025. So I did provide those on page 2 and 3 of the staff report, and then a bit of a discussion on page 3 through the rest of the staff report, really giving staff's perspective on the comments received. And I, just so that I don't be redundant here, I didn't want to go through all of them if you've all had an opportunity to read the staff report, but I'm more than happy to dive a little bit deeper into those if you would like. Just to give me a little bit of direction there as to how much you've already had a chance to review the staff report.
Well, I mean, we obviously reviewed it fairly in detail.
Okay.
In the initial hearing.
Sure. Okay. Well, I can just go through these really briefly. I'm sure that the applicant will touch on them, and I'm sure that the appellant will have some comments and in regards to staff's comments to their claims. But I tried to organize these somewhat in decent categories here. The first issue was water dependent versus water related issues, where the appellant claims that the RV park is not water dependent and therefore is prohibited in the marine activity zone. Staff did go back into the final order on page 21 through 24, which determines the project does support tourism directly linked to water, recreation, boating, kayaking, and fishing on the Rogue River, and therefore staff believes it does qualify as a water-related or water-dependent use. The decision also imposes transient use only restrictions, ensuring alignment with the intent of the MA zone. I do understand from reading the applicant's comments that were submitted yesterday that there is a discussion of whether or not, if it's not transient use under the water dependent or water related commercial use, that they do have some comments to discuss on the temporary use option for the site for the proposed project. And I'll let them discuss that in more detail. The second comment by a variety of the public was that the project harms a riparian habitat and violates Goal 5. Under the Curry County Zoning Ordinance 3.280 through 3.283 and 4.011, the ordinance allows development of permitted uses in designated riparian areas, provided that there's mitigation or that there's no net loss to the riparian habitat. And as such, the final order does mandate a riparian landscape plan approved by the Oregon Department of Fish and Wildlife. This must be done before permits could be issued for the site. And they would have a planting plan in addition to any other requirements that ODF and W had. We believe that the site, or staff has said in the staff report, that the site is currently not, does not have any riparian tendencies, if you will. I mean, there are some plants on the direct shoreline within the riprap and adjacent shoreline, but not your typical riparian area. And what's being required by this decision, should the board approve it, is that they would have to create a riparian area in accordance with ODF and W's requirements that doesn't currently exist there. So that does meet Goal 5, and it also does enhance the riparian corridor, which doesn't currently exist. We'll also say that the 2015 Rogue River Estuary Strategic Plan also didn't propose any prohibitions on development adjacent to the estuary. It instead discouraged new floodplain construction that wasn't in compliance with the FEMA regulations, but it did promote protection of the riparian area and wetland buffers, and encouraged voluntary compliance of new riparian standards. So, and that was a plan that, although 10 years old, did have a lot of public input. From what I understand, of course, I wasn't here at that time, but in reading through that document, it does provide opportunities for development, provided that they don't generate any net loss to what's already there. Next is the floodplain and stormwater protections. Elevation certificates were provided. Anchoring standards for the buildings that are being constructed were provided. Flood resistant construction materials will be used, and there also is an engineered stormwater plan that the code requires be in place before development can happen. And because of that, some of the arguments that the RV park can have risks of contamination or site instability from floodwaters, we believe that the stormwater plan that's put together by the engineer meets the code requirements, and also probably provides more protection than what's currently there. That currently sheet flows from Wedderburn Loop Road to directly into the river without any detaining or treating of the surface water. Compatibility with surrounding uses. Although this is a discretionary decision, the appellant claims that the development is incompatible with the coastal zoning and recreation, or residential areas. County would say that Curry County Zoning Ordinance, Chapter 7.040, subsection 1 A through B authorizes additional buffering and access controls or off-street parking conditions when necessary to eliminate any incompatibility issues. And this is pretty common in any type of development. If you have commercial development adjacent to residential use, oftentimes the commercial use will need to buffer from a residential area. The final order that's provided to you in draft form in this decision requires more on-site parking than what was proposed, specifically to keep people from parking on Wedderburn Drive or creating any off-street loading or unloading issues. There was also a condition for circulation and signage plans to prevent roadside congestion, and considering that and the separation of the project by Wedderburn Road, I don't feel that there are any necessary incompatibility issues that haven't been addressed in the conditions of approval. Procedural adequacy and jurisdiction. The appellant claims that the county erred procedurally and violated land use review standards. We responded in the final order that Curry County Zoning Ordinance 2.170 through 2.190 and ORS 215 confirmed that the appeal process was properly noticed. This is de novo hearing, so new evidence can be admitted, and it is consistent with state land use procedures, that we don't feel that there was any violation of noticing requirements or due process. Temporary versus permanent uses. The appellant claims that the permanent infrastructure conflicts with the temporary use allowance, and I'm going to let the applicant speak to that in more detail, since they have a recommendation for supplemental findings to the final order. But the final order that was provided to you explicitly categorized the RV park as non-temporary, finding full compliance with floodplain and the marine activity zone standards through transient use conditions rather than temporary authorization. So I do believe that the permanent use is allowed in the MA zone because it is water dependent, and that the condition that it's transient use does protect that from being more permanent living situation, and therefore being more water dependent use for tourism and such. But I will let them speak a little bit more to that because, like I said, they did have a potential second option and some supplemental findings that were provided yesterday. Excuse me. Comprehensive plan consistency. The comments claimed that the use conflicts with the Curry County Comprehensive Plan, statewide goals 16 and 17. Final order that's provided to you on page 20 through 24 of the final order, not the record, concluded that the RV park supports goals of coastal economic development and public access without degrading the estuary values. And Curry County Zoning Ordinance 3.240 and Goal 16 prioritize water-related commercial development consistent with shoreline management objectives. And again, going back to the 2015 Rogue River Estuary Strategic Plan, which was in compliance with Goal 16 and 17, I do believe that that there isn't a compliance issue with statewide planning goals 16 and 17. And I think it's also important to note that quasi-judicial applications don't always have to address statewide planning goals. The statewide planning goals are incorporated and adopted and approved by the state through the county's comprehensive plan, comprehensive plan is what drives the development of your zoning code. So there doesn't always have to be a reference to compliance with goals 16 and 17, but since the issue was raised, I just wanted to make sure that the board understood that we believe from a county's perspective that goal 16 and 17 is met through the findings and through the adoption of the comprehensive plan. And then, so that was pretty much it for the comments that were submitted through October 20th. I don't have much to add for the new public comments that were provided by, it looks like, Joanne Moss. Those were provided yesterday, and really say a lot of the same that was provided in previous comments. So I didn't provide additional comments or reactions to those comments. And then, of course, I did not address the applicant's rebuttal comments either. So I'm happy to answer any questions. I think it might be best if we open the public hearing and take the public testimony and then ask staff additional questions after the public testimony is received. That way, maybe some of the questions that the applicant may answer, the appellant may answer, I'm not trying to find answers for those.
Certainly. But quick procedural question. Since we didn't close the other hearing, do we just recognize this as the continuance, opening of the continuance? So we will do that. We will now formally open the continuance of the initial public hearing, and we will take testimony as follows. We will allow the...
If I may really quick, just read that statement, the opening statement, which is the instructions for the public testimony. It was read before. It doesn't have to be read again, so if the board doesn't want it to be read, it doesn't need to be, but it is always a good idea to make sure that everybody understands the procedures for how we're going to take public testimony.
So we will open the public hearing for consideration of an appeal, AP-2502 of Planning Commission decision upholding the Planning Director's approval of AD-2431. And is that what you were seeking?
Well, I have an opening statement that talks about how evidence is taken in, what criteria apply, applicants' timeframes and such.
All right, well, move forward with your opening statement.
Okay. Planning staff has determined that the approval criteria that apply to the application currently before the Board of Commissioners are as follows. Section 3.150, Section 3.190, Section 3.220, Section 3.240, Section 3.251, Section 3.280, Section 7.040, and the Curry County Flood Damage Prevention Ordinance. Evidence and testimony in this hearing must be directed towards these criteria or other criteria in the county's zoning code, comprehensive plan, subdivision code, or other applicable land use and development-related regulations that the person believes applies to this decision. Failure to raise an issue with sufficient clarity and detail to afford the decision maker and the parties an opportunity to respond accordingly to the issue precludes appeal to the Oregon Land Use Board of Appeals on that issue. Before the end of the hearing, any participant may request a continuance. In addition, whether or not a continuance is granted, a participant may request that the record of the proceedings remain open for at least 7 days after the hearing. The Board of Commissioners will consider whether or not they will continue the hearing or leave the written record open for a specified length of time for new written testimony or evidence. When the county reopens the record to admit new evidence or testimony, any person may raise new issues that relate to the new evidence, testimony, or approval criteria that apply to the matter at issue. We would ask that when you're called to speak, please either come to the microphone or unmute yourself if you're identified by the chair if you're on Zoom, and state your name and residential address for the public record. Again, please direct your comments to the applicable criteria as identified by county staff, and that the following time limits are allotted for public testimony. And Mr. Chair, you can adjust these accordingly depending on how many people are here to comment. But generally speaking, we'd give the applicant 10 minutes to present their arguments, and then individuals, including the appellant, would have 5 minutes apiece, and then the applicant's rebuttal would be granted 10 minutes. Following the close of the hearing, the commission deliberates and renders a decision if the hearing's not being continued. And that pretty much is it. If anybody had any questions or do not understand the procedures, you can ask the chair of the Board of Commissioners or county staff to explain the process.
Thank you. I have 3 public comment requests at this time. And so what I will do is I will open it up to the applicant for your opening statements. You have 10 minutes. Mr. West, go ahead.
Good morning. Can you hear me okay?
We can. Thank you.
Awesome. Thank you. And thanks for allowing everyone to appear via Zoom. Makes things a lot easier. So the record was kept open from the previous hearing. So, most of this time should be geared towards hearing additional comments from members of the public on this application. Ultimately, the applicant agrees with staff and staff's findings in the staff report and the proposed order. I did add a response letter into the record yesterday, kind of going through some of the issues that have been raised, throughout the entire proceedings. Of particular importance is the issue raised about potential native cultural resources on the property. I included several pictures in my response, which was included in an original survey of this part of the county, and some photos from the late 1800s and early 1900s about the property. I think it's improbable that there was a native village on this particular property, but I think it's probable that there was a native village in this area. And so, in any which way, we are proposing a condition of approval to impose an inadvertent discovery plan on the development. This is a pretty standard practice, and this says that if during development any archaeological finds were made, that there are certain procedures that need to occur, which would include, of course, immediately stopping work and contacting the appropriate authorities so that nothing can be disturbed while an analysis occurs. We did some legal argument concerning the water-dependent use, which stays in line with our previous arguments. Most of it was a response to some LUBA case law that had been cited at the last hearing. We do stand in our position that this is a water-dependent use under the county code. But like Zach said, we do have some alternative findings that the county could adopt if they wanted to, related to temporariness of the use, which would basically impose a expiration date on this use of 10 years to keep it within that kind of temporary realm. You don't have to impose that if you don't want to, but I did include it in case discussions kind of went that way. That way you have something to go off of. Really, our request is to approve the application with the conditions that have been suggested by staff and that the applicant has agreed to. I did want to make a quick clarification to my response. I said on page 5 that we had included a landscape plan in the record, and page 10 a parking plan. Those plans have not yet been submitted, so we will submit them at the time of planning clearance. So my bad in putting those in our response. The most important thing, though, is whatever the board decides, there's a high probability this will go up on appeal. So it's important to make sure that the final order has a response to all the issues that have been raised, because that's usually like the first thing that's brought up on appeal to land use board is, we raised this issue and they didn't talk about it in their order. So I do have the proposed supplemental findings for the board's consideration to adopt. You don't have to adopt them. You can adopt part of them, whatever you want. But my hope is that that provides enough of an analysis of like, look, this issue was brought up. Here's where it was brought up. Here's how we kind of go through it and address it. That way we keep everything at a level playing field and fair. So ultimately, if this is approved, make sure to adopt the proposed order from staff, consider adopting the proposed supplemental findings we wrote, and also take a look at the temporary use findings we wrote to adopt. Ultimately, it's your call. Really, I don't have anything else to bring up at this point. If you do have questions, I'll be available. And Sherry McGrath, our land use planner, is also on the call, who might be able to answer some of the more technical details as well. Yeah, thank you so much for your time. Really appreciate it, and I'll reserve the remainder of my time if needed for rebuttal. Thank you.
Thank you, Mr. West. Now we will take public comment. And I would ask that you please respect the time limits of 5 minutes. And Tabitha, you are up first.
Well, thank you guys very much for the opportunity to continue this hearing. I just wanted to provide a quick recap. I think a lot has been mentioned already. But it was mentioned by the planner that the appeal process did not violate any of the zoning ordinance. I agree with that. However, the application and the approval of the land use decision were not properly notified to NAIC, who had reached out to both the landowners and the Board of Commissioners in 2024. Second, the county has charged Northwest American Indian Coalition more than the state legal amount to appeal this decision on 2 occasions, which should result in a refund, and that has not been addressed in any of the staff reports. The decision is essentially in violation of the county code on a lot of our opinions and relies on non-existent staff and operations and a severely outdated comprehensive plan, 2009, and no known time of updating this comprehensive plan to meet the conditions of this permit, which 32 out of 40 of these conditions have additional conditions to be met to actually meet the requirements. We believe the decision would cause irreparable harm to the adjacent landowners, the community of Wedderburn, and the Rogue River Estuary, despite the argument that its installation would be temporary or transient. 10 years is hardly a temporary use. And there are several severe contradictions within the permittance. I would encourage everyone to look at the photo of the site or look it up on Google Earth and tell me that it's not a riparian site, because I find that very difficult to argue. I think that the zoning ordinance is in place to protect the quality of air and water resources for the people and the life and property, and conserving especially historic, cultural, and natural and scenic resources. Trying to be brief here. I mentioned the lack of applicability of riparian buffer zone and estuary requirements, which specifically relates to drainage facilities, utilities, and irrigation pumps, specifically listed as prohibited uses in the zoning ordinance 3.283. I think this is an unjustified dismissal of the applicability of these rules. It is also known that the Wedderburn Sanitary District is already an outdated system that cannot take on additional users. And there are not funds currently to renovate the system, nor would this permit assign any funding to renovate that system for people that currently live there, which, as we heard in the past hearing, there are landowners that are already concerned with their water quality and delivery on that side of the river. County goals that we see were violated, at least as Goal 5, and statewide goals in conflict with this decision, which I understand maybe you don't have to meet in full, but definitely Goal 7 and Goal 16. I think we realized that the alternative for the development of the RV park, which has been mentioned, the development of an intertribal cultural center where there has been a native village site, and with all due respect to Mr. West, you are not a qualified archaeologist, and so I think that that's an unfounded opinion of whether there was a native village site there or not, as there are members in this audience that would attest to otherwise. It is not the present concern of the county whether this alternative is installed, although the efforts made to negotiate with the current landowners are applicable to the known interests of this appellant group and as it relates to the notification of this application and decision, as I mentioned. In choosing the execution of the comprehensive plan and Curry County zoning ordinance through permits like this one, I believe the county is choosing to allow development that is counterintuitive to the purpose of these plans to protect resources. This place on the Wedderburn Loop is special, ecologically, prehistorically, historically, and contemporarily, as it is one of the primary economic drivers and sites to be seen when driving over the Patterson Bridge into or out of Gold Beach. I believe it is abhorrent to ignore both the significance of this place in approving this permit for yet another RV park, one of almost 12 in this town, as well as the potential to recognize and honor this place for the benefit of existing residents and visitors to Gold Beach. We hope that you reconsider the temporary nature of this approval this land use decision in general, and realize that this lasting symbol it will leave on this area, one that prioritizes tourists over locals and potential taxes over limited and irreplaceable resources. Thank you.
Thank you. Tabitha, I apologize. I don't know if you read your name into the record before.
Oh, I'm sorry. My name is Tabitha Rood, and I live in here in Gold Beach.
Thank you.
Thank you.
Next is Kelsey Dunn. Oh, Kelsey, you're online? There you are.
Yes, good morning.
Thank you. Go ahead.
Good morning, commissioners. My name is Kelsey Dunn. I am an attorney at Craig Law Center in Portland, Oregon, and I'm here on behalf of Appellants Northwest American Indian Coalition, Oregon Shores Conservation Coalition, and Dr. Diane Hennessy Powell. Thank you again for being here today to continue consideration of this important issue. I'm primarily here to answer any questions you have about appellant's position or the comments we submitted on September 22nd and then October 20th. But I also just wanted to highlight a couple additional points. First, as we describe in both of our comments, the RV park is not a water dependent use under the county code's definition or state law, and we recognize that the county code does, incorporate the goal 16 and 17 language. And so again, we're saying that it's not a water dependent use under either definition, nor can it be approved as a temporary non-water dependent use. As the updated staff report correctly identifies, the county has already determined that the use is not temporary. Applicant now suggests that there could be a 10-year expiration date or some kind of timeline put in place to make it a temporary use. We haven't seen that language in the comments, so we can't really analyze or give our thoughts on whether or not that would be sufficient. But regardless, as our comment submitted on October 20th discusses, the permanent nature of the infrastructure would likely mean that even such an expiration date wouldn't satisfy the temporary requirement. I also just wanted to point out that the temporary defect cannot be solved through transient use conditions. Neither the county code nor state law makes a transient use condition exception, and the staff report doesn't identify any other authority for why using transient use conditions would be sufficient to meet those requirements. So we just encourage the commissioners to take a closer look at that issue, as the applicant has also encouraged the commission to do. Second, as Tabitha just mentioned, appellants respectfully request the board to make a determination on whether to refund the excessive appeal fees already paid by appellants, and we discuss our arguments for that in the September 22nd comment. And so again, we would just hope that the board makes a determination on that issue in their findings. So if there are no other questions, I can end my comment there, and just again appreciate your consideration of this issue.
Thank you, Ms. Dunn. Oh, next is Katrina Thompson-Upton. Awesome signature, by the way. Right, yeah. Natasha, can you pause clear and prepare the clock for, there you go, thank you.
Katrina Thompson, Curry County
Sure,
resident.
I mean, did you need a minute to find your notes? I mean, it's,
I'll be brief. I just
Okay.
wanted to reiterate what others have said and to thank you for allowing this hearing and to hear our concerns. And also to mention that Northwest American Indian Coalition's primary goal is to preserve the history and the culture of Curry County, which is quite vast and extensive, and deserves to have the comprehensive plan that's dated 2009 updated. I think we wouldn't be here today going through this hearing if the comprehensive plan acknowledged the vast culture that is in Curry County and had some of the sites like this one listed and honored and on the list to be protected. And so that's one of our main concerns, is to address that comprehensive plan. And also to address the need to have greater consultation with our neighboring tribes, to allow them consultation and notifications when there are issues in development near SHPO sites, and also to adhere to federal NAGPRA laws and regulations. And that's really our two main concerns today that I wanted to comment on, was the outdated comprehensive plan and ensuring that we hear and ask for and acknowledge and honor the voices of our neighboring tribes when it comes to important ancestral sites. And I will leave it at that. Thank you.
Thank you.
Thank you.
Okay. At this time, at this time, we would allow Mr. West to have time to rebut the public statements that we have received. Should you choose to, you will have 10 minutes to do so.
Thank you very much. I just want to address a few of the points that were brought up. Number one, on the fees issue, I think it would be appropriate for the commissioners to make some kind of decision once you get into the deliberation on the fees. That way we have something in writing, whatever you choose, to kind of clarify the county's position on that. For the archaeological issues, yeah, not a licensed archaeologist, so I'm not claiming to be. I did go through photographic evidence and the surveys, though, to try and find something. So that's what I put in the record. With the water-dependent use issue, I do think that Crag Law's summation of the case law is incorrect. I don't think that is what that case says. The commissioners should take a look at, the county's own rules, make a reasonably informed interpretation of that rule and apply it to this case. On the comp plan issue, and making sure we have more discussions with Native peoples and tribes in the community. There should be, we should have more discussions. I think that's really important, especially having some kind of community forum in the future. Having a 2009 comp plan, though, I'm actually really impressed. Jackson County's is like many, many decades older than that. It's older than I am. So I think you guys have done a really good job with that. Lots to do. A lot of issues have popped up. I'd recommend that, you adopt the proposed order and approve the application. Take a look at the proposed supplemental findings for your adoption. And if you think that there's some issue with the water dependent use, there are some backup findings with the temporary use findings I drafted up, but I don't think that's needed, but it's always an option. Otherwise, happy to answer any questions before you close the public hearing. It might be a good time to ask Zach as well. That way, if there's anything that needs to pop up regarding new evidence or something, that can be made. And then close the public hearing and have your discussion. So thank you very much for your time. Much appreciated.
Thank you, Mr. West. So I will ask Mr. Moody, please come back on here. And do you have any final comments? In particular, I'd like to hear your our interpretation on the refund that's been brought up a few times now. So go ahead.
So I'm sorry, I was reading through something when you were closing the hearing. I didn't hear you actually.
I haven't closed the hearing yet.
Okay.
I'm allowing you to have some last minutes, and then we will close the hearing, and then we will deliberate.
Gotcha. Okay. So a couple of things. So to the issue of the fee, yes, statutorily the fee maximum is $250 in accordance with ORS. I do believe the applicant had their opportunity to appeal at the Planning Commission. The issue at hand at that Planning Commission meeting was findings, or excuse me, was their ability to participate in the process. That is why that meeting was opened and then closed, is because it was determined that they didn't have standing, and there wasn't really much of an argument made at that point that we felt was relevant. So I believe that that fee should stand. I do believe that the fee should only be $250. The fee schedule does say $500, but it clearly is not compliant with the statutory limits. So I would recommend that the board authorize through the final order and leaving probably a finding in there to address that issue as it was raised, to refund $500 of the $1,000 that was paid. That would be $250 for each hearing.
Okay.
So that's the first issue. The second issue raised by Mr. West was the issue of the findings that he's provided supplementary findings for. I guess the question for the board is, do you want to have a discussion about temporary use versus the permanent water dependent use? And if you do, I think that will require a discussion of additional findings that that we can provide in the final order to support that. My recommendation is that I believe that the order that it is currently written, the use that's currently proposed, the permanent water dependent use, does meet the standards of the Curry County Zoning Code and the Curry County Comprehensive Plan, regardless of their date. I do believe that our goal or our requirement is to determine that the application meets the current standards that are adopted by the county, and that if there are other case law issues, those should be dealt with in a different forum. And if they would like to challenge those case law issues, I don't believe that there's any reason to do so, but should they feel that there is, that the next step for them would be the Land Use Board of Appeals to appeal the county's decision. What I will say is that we granted approval, or if you grant approval, I don't believe that there is a lot for the county to need to argue with the Land Use Board of Appeals. This will be an issue between the applicant and the appellant at that point. LUBA may remand back the application. That I suppose that is an option that they may have. They may remand it back with specific instructions for review. But at this point, I would still hold that the findings support the decision as it was proposed, and that we might want to look at some of the additional findings that were provided by the applicant, and we can go through those individually and see if there are any that you want to incorporate into your own findings. But aside from that, yes, fee refund. I think the decision is still supported by the original final order with some supplemental findings that we might make.
Okay. Well, thank you. We will go ahead. We don't really have time. We will close the public hearing. And now we will discuss how we would like to proceed. Mr. Coker.
In terms of the claims relative to the comprehensive plan, in terms of the comprehensive plan being a 2009 document, it's been positioned to us that there's a body of evidence that says we're better than some, and then there's the claim being made today that as a result of a 2009 plan, there's actually important settlement considerations that simply aren't on the radar screen. And that troubles me, that we might, in essence, be driving a little bit blind. And I need somebody to help me to go through the discussion of how we can set aside the claim that we might be flying blind.
Regarding the comprehensive work, the land use plan.
Correct.
And I think that would probably require a whole different meeting. We're not here to deliberate whether or not whether or not the land use plan is sufficient. It is what we have. Now, I would want to entertain a future discussion on whether or not we should allocate the resources to have it updated. But I don't know that this would be the appropriate space to litigate that topic.
So if we were to, just through our own stewardship role, if we were to create a pathway for opening up the discussion regarding the implications of a 15, 20-year plan, what would be the pathway that, as a board, we would take, and/or the property owners and the claimants here would take? What's that process that they would go through, if any, that we know of?
Not regarding the comprehensive land use plan. That's a executive function relegated to us in terms of proceeding forward with the process of a study and adoption of whatever elements we'd like to be changed or updated. This would be completely, in my opinion, independent of the case before us. Now, the results may change future decisions going forward, but I'm not exactly sure what you're leaning towards, what you're saying.
I'm attempting to not fly blind in making the choice today. And I believe that we're being...
But I need clarification, because essentially what you're saying then is that our current comprehensive land use plan, it should be not adhered to? That's blind? We have a comprehensive adopted land use plan that we are governed to follow. So I don't understand how we could be flying blind. That's where I'm troubled.
It's a little bit like being offered counterfeit money at a grocery store. I'm about to make a decision on purchasing something at the grocery store, or selling something at the grocery store, but the currency is counterfeit. Here, I'm sitting at the dais, and I've been asked to make a choice, and there is possibly counterfeit or flawed information, not because people are bad, but rather just because it's dated. That the plan that has been relied upon since 2009 may have some flaws that we wouldn't ever want to have in there, but they may be. And we have a group of our community members who are saying, yes, the plan doesn't include what we know to be part of our history. And so I've got the data in the plan, and I've got the data from our constituents. And I'm saying it's difficult to understand how we reconcile that information in our stewardship role.
But I also want you to recognize that what you would be recommending is a complete reversal of all rulings that have taken place under this comprehensive work plan, and then everybody who is subject to this land use plan or denials in the past would now have what you're stating as precedents for appeal.
Well, so be it, if that is what unfolds. I don't know that we have the capacity to even raise the question of folding the plan in. I'm looking for what are conceivable instruments that we can bring forth that will allow us to reconcile the intellectual challenge of two data points that are dramatically in conflict with one another.
But the data points, okay, I guess here's my issue. Is we're now litigating the validity of our land use comprehensive plan, not whether or not the applicant is requesting use that's within it. So that is a, well, number one, that's not what we're here for. We're here to decide whether or not the applicant's proposed use falls within our current adopted lawful land use plan, just because it may not be it may not be,
I'm eager to hear how you characterize it.
well, just because it may not be what everybody in this room desires, does not make it any less lawful or adopted. So I'm asking, are you requesting that we pause this entire hearing and move forward with a year or two's effort of a renewed comprehensive work plan and make no planning decisions for the next 2 years while that's being done so that we can hear this case? Because that would be the result. I'm sorry, this is not for you. It's not public open comment.
Thank you. So I'm not prescribing anything yet. What I'm doing is I'm questioning, and I'm still at the point where I have data points that conflict. I understand from what you've represented here that whatever pathway we take to try to reconcile the data points, it involves a lot of calamity, a lot of work, a lot of time, and it's outside the scope of this hearing.
What I would caution in terms of going down this road is no more different than what a judge, which is what we are doing right now, is ordered to do in a court of law. They may not agree with a law and believe it needs to be updated, but that does not give them the authority to overrule it. So we have a situation before us that requires a decision. And all we can do is use the information that we have before us. Now, the beauty of this scenario is that we actually do have the authority to change that, but we haven't. And the process in doing so would prohibit any planning clearances going forward until that was completed.
Well, that was my question. What is the pathway and what are the implications? Now I understand that.
So I mean, obviously, Mr. Moody can step in, but I don't know if you have if any of that is directed as a question towards him or just discussion between us. But
if you don't mind, I'd like him to comment on it if he can.
Sure.
Sure. Thank you for the opportunity. Yeah, I think what's important to note here is that we have an application that was submitted on a specific date with the goalposts fixed of the rules, right? So in any land use action, and this happens all the time with people that know there are changing rules coming, and they will submit an application to basically ground their particular request in the current code. And despite what you might change in the comprehensive plan this year or next year, if you were to put this on hold, which I don't recommend, but if you were to put it on hold, and that was the reason why, is because you wanted to get the comp plan square before you made a decision. I do believe you would be setting yourself up for failure at the Land Use Board of Appeals on that issue. Like it's been said, many comprehensive plans are not always up to date. It's not common for even big jurisdictions to, or metropolitan areas or areas with big populations, to do comprehensive plan amendments maybe once every 5 or 10 years. That would be unique. Most of them do periodic review at a specific time frame, and they adjust their comprehensive plans to be more compliant with state law. The other issue is that, this application doesn't necessarily address, at least in my opinion, doesn't have to address all the criteria in the comprehensive plan unless it's directed in the Land Development Code to do so. The Land Development Code is adopted based on the policies, goals, procedures, implementation steps in the comprehensive plan, and the Land Development Code is what is applied in this particular issue. Now, there could be lots of arguments for why you would apply a comprehensive plan individually instead of your Land Development Code, but in this particular application, there are standards or criteria for everything that's addressed. We did add additional language, for goal 16, goal 17, some comprehensive plan language to support the approval. But again, I think if you're concerned that the comprehensive plan runs afoul of state law or Oregon planning goals, the opportunity, I mean, I would be recommending approval if the board made a decision to approve an application. Again, I don't believe that we would have much to argue with the Land Use Board of Appeals. I do believe that if there were compliance issues with the comprehensive plan as it pertains to state law, that would be handled between the applicant and the appellant, and case law would be reviewed by the Land Use Board of Appeals and the attorneys that would be supporting those cases. And staff doesn't participate at the Land Use Board of Appeals necessarily. Those are generally attorneys that participate at that legal, because you are trying to validate or invalidate case laws to a specific point. So that's all I can really say about that. I think that if you dive too deep into the comprehensive plan and where it might not be totally compliant with state law, I think you're going to find that that's the case in a lot of the elements of the comprehensive plan. But I don't think it makes a major impact in this particular decision. The opportunities have been there to comment by the public. All the evidence that the public wants to provide has been provided, and you have that information to make this decision. And I believe that you're obligated to make that decision. And sometimes you have to deal with the laws that you have in place or the regulations that you have in place.
Thank you, Mr. Moody.
So I guess my suggestion would be, if you still have reservations, because I would certainly not want you to make a decision that you have reservations regarding, but I would also not want you to not make a decision if there were no specific actual areas that you feel need to be changed that would directly affect this case. And if you need time, we can always, I'm certain that, this is our decision. And so we can take time if you want to review those things. But I would have a very difficult time with a blanketed statement that there may be some things that need to be changed, and we have no idea if those things would actually affect this outcome. And if we don't have specific examples, or you have not brought any, then I would ask that you take the time to find those to serve your concerns.
Well, my concerns are resting on the information provided, and it argues one with the other. But my questions centered around process and how do we proceed? What are the avenues that we can legitimately take under the umbrella of this particular hearing? And you have answered that for me, and I'm grateful. Mr. Moody has helped fill in some blanks relative to the implications of what it means to operate under a comprehensive plan and what are the pathways for changing a comprehensive plan and the implications therein. So that portion of the concerns that I wanted to raise in this hearing have been addressed. I would like to move on to a second consideration, and that's relative to the refund. What's the process for discussing that and when?
Well, yeah, sure. Yeah, let's go ahead with that. So I think it was reported to us that we should extend the appellant a refund of $500, which is half, apparently, of the overall appeal costs. I obviously have no objection to that. The one thing so, sorry, do you have any more questions regarding that?
No, I'm in alignment with that. That's great. I just didn't know if we would be able to wrap that up in today's discussion.
I think we make it part of whatever decision we choose.
Okay, good. Me too.
And but the one that that I'm would like to have more discussion on is this time-based option of essentially a ruling with an expiration date. And so Mr. Moody, can you provide clarification on how for that discussion?
Well, sure. I mean, again, after preparing the findings for the Planning Commission hearing and for you all, and after reading testimony and arguments in opposition, arguments for, aside from there being an original question of where is the MA zone, where is the commercial zone, does this particular use fit in the MA zone? Is it a water-dependent use versus a water-related use or a non-water related use? I do feel that the findings that have been presented to the public and represent what I think the board should adopt. I think those are sufficient to move forward with an approval, because we do have a finding for every single use. Yes, the appellant doesn't agree with those. I did go through those comments and where I believe we still meet the requirements. That does not change my opinion on whether or not it should be approved as a water dependent or water related use. I believe that it still should be approved that way. I do agree that trying to do something on a temporary time basis, for 10 years, I feel like that might be hard to enforce. Might be hard to move people out 10 years from now. And when you have to enforce on that, I think you have a much better, more solid decision if you call this particular use water-related or water-dependent use based on the findings that were provided.
On the findings of what, Mr. Moody?
On the findings that were provided in the staff report in the final order that's proposed to you today.
Thank you.
And I do believe, one other thing, I do believe that it probably is worth taking some time to review the findings, all of the comments really, that were provided today. You have a lot of information that was provided to you in the last couple of days that I'm sure you have questions to, or you want to consider how you might amend this decision to incorporate specific issues that were raised. It is not not out of the question for you all to continue deliberation at a different meeting time. Of course, you would not open the public hearing again, but you can take this information that was provided today, take the testimony that was provided today, and you can, reschedule another meeting to another date and time specific and complete your deliberation if you don't think you can get through it today. That is an option. That way you don't feel rushed. Or we can take the time today and go through the supplemental findings that were provided by the applicant and see if the board wants to incorporate any of those proposed findings into their final order, into your final order.
Thank you.
And I would leave that up to you. I mean, if you would, there is a lot of information here
There was,
that
yeah.
should be very carefully considered.
And on that point about it being a lot of information, it's really good information. But I don't think that there's been enough time to weigh it in a manner that is respectful for the quality of the information and the implications of the solutions that have been suggested.
So, are you proposing that we essentially close this meeting, come back, deliberate at a different date to make a ruling and move forward after considering all of this?
I would like that very much.
Okay.
How about you?
I'm not opposed.
Okay.
There's certainly a lot of information here to digest.
Good. Yeah.
So,
Yeah. I'm not begrudging the opportunity to do right with it.
no, and I obviously respect your desire to be extremely thorough in examining all of this information as well. So, what we would do at that point then is we would ask that, Mr. Moody, you make yourself somewhat available to answer maybe some questions that each of us will bring to you independently. And then when we come back, we will discuss what we found and move forward with a decision of some sort.
Yeah, I think that sounds reasonable, and I think it gives you all an opportunity to again see what you want to incorporate into the findings, on either side, or what needs to be changed, because this is your final order, right? As a board, so we want to make sure that it represents what you all want it to say. What I will say is that statutorily, as far as the timeline is considered, we are over the 150 days. We've been given extensions of time by the applicant to continue. I don't think that there'll be an issue, but if the board would allow Mr. West to just speak to see if he would grant a addition of the timeline so that we can continue this process under a statutorily approved timeline, that would be great.
Okay. Mr. West, what say you?
Yes, of course. More than happy to grant a reasonable extension of time. My only suggestion would be that if you're doing a continuation for deliberation, you give a time certain right now, so I can consent to that. And if we need to do an extension further because of rescheduling, we can do that too.
I agree. I'm thinking that we look at the morning of November 12th, which would be a week from today. How does 10 o'clock work for everyone on this? And you're good with that, Mr. West?
Great for me, yeah, and I consent.
Moody?
Yeah.
Okay. Mr. Coker?
Yes.
Okay, so what we will do is we will adjourn this meeting, and we will reconvene on November 12th at 10 a.m. To further deliberate the findings in which we've been provided over the last couple of days.
Can I ask, Mr. West, who got a copy of the material that came in?
Should be in public record.
So,
So if I can, just because the public hearing's not really open anymore, but I will update the record so the record can be posted online so everybody has everything current through today. The only two things missing from the record are the public comments received by Joanne Moss and the public comments received by the applicant, which I will incorporate those into the updated record, and that'll be made available online for everybody to see. And we can go from there. Of importance to note, though, when you do return, there won't be public comment. The public comment period is essentially over with the record, or excuse me, with the public hearing closed. So it'll only be for your deliberation to craft those findings the way you want to see them.
So, real quick, there's been a concern that the appellant would request that this document not be made public. One thing that I'm concerned about, Ms. Upton, is that it's already public because it's been discussed in a public meeting.
It's not on the website yet, though.
No, but we've all been given it as public reference, and we are in a public session. What I would ask is that you provide your objections to certain pieces of material in writing, and then we can consider what it needs to be identified or potentially redacted before it goes up on public media. But as of right now, if somebody were to request it, that would be kind of where we are because we have discussed it in public open dialogue. So
Comments that we made today, do those need to be submitted
They-
to the record?
they already are. When you did them today, they went into the record.
Okay.
Yep.
I was just curious if there's like laws that would be.
Yeah, if I could just provide some clarification. So all the written comment can be accepted through the close of the public hearing. So everything that was provided via email, in person, orally today, until this hearing was closed, is part of the record. And there won't be any redactions because it is what was submitted. If there's an argument as to what was submitted, that would have to be handled upon appeal, depending on what the board's decision is.
Okay. Okay, well, we will, at that point, then, adjourn this meeting, and we will reconvene next Wednesday at 10 a.m. To further these deliberations after all of the considerations of new material. Thank you, everybody, and thank you for your patience.